Glenn was charged for violation of the Comprehensive Dangerous Drugs Act of 2002. During the trial, Glenn expressed his intention to enter into plea bargaining. Despite the objection of the public prosecutor, the RDC granted Glenn's proposal for plea bargaining. The people appealed the RDC ruling before the CA, arguing that the consent of the state is required to sustain a valid plea of guilty to a lesser offense. The Court of Appeals held that a plea of guilty to a lesser offense would never become valid without the conformity of the prosecutor. Is the ruling of the Court of Appeals correct? Explain.
No, the ruling of the Court of Appeals is not correct. The Supreme Court held that approval of a plea bargaining proposal is ultimately subject to the sound discretion of the court. Though the mutual consent of the state and the accused has always been a condition precedent to a valid plea of guilty to a lesser offense. Trial courts have the discretion whether to allow the accused to make such plea. The exercise of such discretion is independent from the requirement of mutual consent. If the approval of plea bargaining proposals is made entirely contingent upon the consent of the prosecution, then the court's constitutionally endowed rulemaking power would be rendered nugatory. Here, the trial court's discretion to approve Glenn's plea bargaining proposal prevails, despite the prosecutor's objection. The trial court, in granting Glenn's proposal to plea bargain, is not bound by the prosecution's consent. The trial court has the final authority to determine whether a plea bargain is acceptable, based on a careful consideration of justice and fairness in each specific case. Thus, the ruling of the Court of Appeals is not correct.